and we are providing public access both in the courtroom and also online. And first going to call out of order, we have People v. Kevin Sparks, 25-93347FH. I discussed with counsel. We had a pending motion and docket call. The prosecutors filed a nollie of that case because of some federal court decisions that impact that. And so the court has signed that. So that case is dismissed. Bring in Mr. Funk. All right, Mr. Funk, good morning again. We're here for an arraignment and People v. Christopher Goldbeck, file 25-93359FH. We've got Mr. McLennan for the people, Mr. Funk for the defendant. Mr. Funk and his client are appearing by Zoom video. Mr. Funk, have you had a chance to review the charges with your client?
Yes, sir. I've got them sit right next to me.
Do you or he wish to have those allegations read into the record?
We waive the reading, Judge. Thank you.
And how does your client wish to plead to those charges?
He stands mute to these charges.
Mr. Funk's defendant remains mute to the charges, which prompts the judge to enter a not guilty plea. The courtroom maintains its steady rhythm as the defense discusses trial length and the specifics of handling the case. The judge remains clear and precise, laying out future scheduling with firm deadlines. It's a well-organized, no-nonsense approach to courtroom management, showcasing a well-rehearsed routine.
Well, under a plea of not guilty on your behalf, Mr. Goldbeck, and Mr. Funk, is a forensic center referral requested in this case?
No, sir, it's not appropriate.
What would be the estimated of the trial?
But you mean the time to try the case?
Yeah, the estimated length to try the case.
1 day, Judge.
Okay. We'll schedule this for a docket call on September 8th at 9:30 in the morning. And I would allow Zoom appearances for you and your client if you so choose, Mr. Funk.
Thank you very much, Judge. I appreciate that.
Anything else for purposes of scheduling from the defense, Mr. Funk?
No, sir.
From the people, Mr. McLennan?
No, Your Honor.
Okay, you're all set today then.
Thank you, Judge. Have a good day.
You too. And let's call People v. Theodore Beck, file 25-93365FH.
Morning, Your Honor. Matt Wood on behalf of Mr. Beck.
Morning, and we're here for an arraignment. Have you had a chance to review the charging document with your client?
We waive its reading, Your Honor, and stand mute as to the charges.
All right, well, on a plea of not guilty on your client's behalf to those charges, is a forensic center referral requested?
It is not, Your Honor.
What's the estimated length of the trial?
Probably 2 days, Your Honor.
Schedule this for a docket call on September 8th at 9:30 a.m. Now, I also, Mr. Beck, have to arraign you on a show cause. It is alleged that you have violated the conditions of your bond and are therefore in contempt of court by having contact with the complaining witness in this case. You have the right to have a hearing on that allegation where your contempt would need to be established by proof beyond a reasonable doubt. You have the right to the assistance of your lawyer at that hearing. If you are found, and you can present evidence in your own defense and question any witnesses presented against you. If you are found to be in contempt or admit to the same,
The tension rises as Mr. Beck faces the allegation of bond violation and possible contempt of court for contacting the complaining witness. The judge delivers a stern warning about the seriousness of the situation, clearly outlining the potential penalties. The defendant's plea of not guilty is entered, but the threat of jail time looms large. This section highlights the judge's firm stance on enforcing bond conditions.
Order you to serve up to 93 days in jail and or pay a $7,500 fine. Separately, if I believe that you're not complying with the conditions of your release, I can revoke that release. And Mr. Beck, do you understand the rights that you had and the possible penalties?
Yes, sir.
And Mr. Voigt, do you know how he wishes to plead to the contempt?
Not guilty, Your Honor.
Okay, we'll enter a plea of not guilty to that and schedule that for a bond violation hearing at the same date and time. And if you could please let Mr. McLennan know whether your intention is to have a contested evidentiary hearing or not that day, that'd be great. Or if there's no further violations and the parties just want to continue to track it, I have no objection to that as well. Now this was set for a show cause. Mr. McLennan, are you asking for any revisitation of bond?
No, Your Honor.
All right, and I did talk with counsel before we went on the record. My understanding is that there is an agreement that there would be a slight amendment to the bond to include no contact with two additional persons. Is that right, Mr. Voigt?
That is correct, Your Honor.
And that's right, Mr. McLennan?
Yes, Your Honor.
All right, so we're not going to put those persons' names on the record we're streaming to YouTube right now. I did receive those names, and we'll put that on the new bond form. And Mr. Beck is aware of who those persons are.
The courtroom settles into a crucial moment where a bond amendment is agreed upon, adding conditions to prevent further contact with specific individuals. The judge underscores the gravity of these conditions, stressing that any violations will result in immediate consequences. Mr. Beck is given a clear message. The court is watching closely, and further violations will not be tolerated. The focus is on maintaining control and ensuring compliance with the law.
And he will sign the necessary bond paperwork to reflect those changes, Your Honor.
All right, so Mr. Beck, I want to impress upon your mind that having any contact with any of these folks is a serious violation, only because the contact in this allegation appears to have been unplanned and momentary. Is it that's the only reason why you're going to walk back out of this courtroom this morning?
Yes, sir.
If you were to have any further contact with that person or any contact with these two additional people, I won't hesitate to have you defend this case from inside the jail cell. Do you understand that, sir?
Yes, sir.
All right, you're all set today.
Thank you, Your Honor. Judge, what will you need to hang around and sign that?
No, because we'll have to prepare that out of the Sheboygan office, I think.
Thank you.
Mr. Vogler, I've got Mr. Darga, I think, from the jail up here. All right, up next, we have an arraignment and People v. Ray Darga, file 25-93366F8. Mr. Darga is appearing from the Crestfield County Jail. Mr. Vogler, have you had a chance to review the charging document with Mr. Darga?
Yes, sure.
Do you or he wish to have its allegations read?
No, neither case.
Is there more than one? I've only got one case up for.
Yeah, 6-6 and 6-7. They have 6-7.
I don't have a 6-7.
I got some documents here for you, Your Honor.